Good morning and happy Friday. I hope everybody has wonderful Labor Day plans for the weekend. I know I sure do. I have work to do. But I hope everybody's going to get out and barbecue or grill or do whatever you're going to do. Enjoy yourself, drink a beer, have fun, relax. Enjoy the holiday. My head's a little muddled this morning. Not my head really, but what direction I'm going to take this little Ramblin. A little muddled. I had a Texas, well, I don't know if it really was a Texas law enforcement officer. I had somebody contact me who said that they were a Texas law enforcement officer, and that I was misunderstanding 3802 in regards to the arrest of the witnesses at Leon Valley. And I was a little gobsmacked, and I asked for a citation or clarification. Obviously didn't get it, never do. You know, it's always one of those things. And anyway, I had some, I'm going to call it free time. I donated some time to something that is completely none of my business. And I went to the law library and I looked up 3802. And yes, I have looked it up before in LexisNexis, but I haven't had someone tell me straight up that, or who claims to be a law enforcement officer, I haven't had somebody tell me straight up that that is the authorization to arrest a witness who fails to identify. So I'm digging through 3802, and I could find lots and lots of things in the last 20 years or so on arresting a witness for giving false ID. That there's plenty of in LexisNexis. But there's nothing on arresting a witness for refusing to identify. Or, let me rephrase it, I could not find anything on arresting a witness for refusal to identify. Doggies in the light. So, I looked up the legislative history of 3802, and I'm probably going to get this wrong, but in 1987, the Texas legislature changed the text of the statute, and they removed witnesses from being arrestable for failing to identify. And magically, after the point where that change became active, magically that language disappeared from all the case law of Texas after that point. So, and again, I don't really know if this was a Texas law enforcement officer. I mean, could have been Texas sheepdog for all I know. But it just doesn't work. So, people always tell me these things, and I'm like, oh, that's interesting. Do you got anything on that? And they're like, crickets. And I'm like, God damn it, no. I mean, it may be possible, and I don't know, but I can't find anything on it. And if I was working for a Texas, if I was an attorney for, like a DA for a city or a county in Texas, I would certainly advise the law enforcement officers that, no, you can't just arrest a witness for failure to identify, because you can't. There's nothing in the law that says you can. And you're going to have a hell of a time getting past that. And the legislature took it out. Like they deleted that section, the witnesses, in 87. You're going to have a hell of a time convincing a judge that the legislature didn't intend to remove that arrest power from the Texas police officers. Oh no, they took witnesses out, but they still wanted the Texas police to be able to arrest witnesses if they didn't identify. Yeah, that makes total sense. Oh, cat. You don't want that cat. Oh, you want the sprinklers. Anyway, so there's that. The Gilroy police officer who arrested California Guardian. My own personal psychologists have held that it hurt me to make that video. I don't understand that. I mean, if you just match up my philosophy, there are no good people, there are no bad people, there are people who are currently doing good things, and there are people who are currently doing bad things. Everything's on a scale. Everything is shades of gray. Then I don't know why you would think, how you could think that I would think that the police are good all the time. I've also stated explicitly that any institution that has humans in it is going to have a percentage chance of corruption. There's going to, one human may not be corrupt, 2 humans, your odds of corruption just doubled. I mean, it's not doubled necessarily. I'm sure there's some sort of mathematical formula, but the more people there are, the more likelihood there's going to be corruption or stupidity, ineptness. That's just the nature of anything that has people involved in it. So yeah, the reason why I don't always showcase where the cops do wrong is because they are already condemned in the community. Everybody's like, this cop is wrong. And I'm like, yeah, that cop's wrong. What am I going to add to that? The difference is in the California Guardian case is that he was quoting laws. He was misquoting laws. And there's also that weird thing that Hemming must be teaching. I don't know. I don't watch Hemming, but it seemed like everybody in his chat and Hemming himself seemed to believe that somehow the suspect misquoting cases to the cop would strip away qualified immunity. I don't think the cop would necessarily have qualified immunity in that Gilroy case to start with. But if he did, I certainly don't believe that California Guardian, who is not an attorney, who is not that officer's attorney, especially, I certainly don't think that, and who is a suspect, I certainly don't think him spouting off bad case law, not bad case law, but misquoting cases or misapplying cases, I certainly don't think that would have any legal effect on the qualified immunity of the officer. So that's why I brought that up. Was the officer wrong to arrest California Guardian? Yes. Can California Guardian sue? Yes. Is he going to win a ton of money? I don't think so. I mean, he may win some. He may get like attorney's fees. He may prove a point. But he's certainly not going to retire rich off of it. That's for sure. But can he sue? Yeah. Can he win? Yeah. I haven't seen anybody arguing lately that a settlement is a win. That used to be Tom Nack's favorite thing. A settlement is a win. If they settle, that means you won. No, well, I mean, it means you won monetarily, but it doesn't mean that you were right. One of the sad facts of working in the legal field is that you see kind of the failings of it, and in civil there are costs associated with defending a case. There are fewer costs for the plaintiff, especially if the plaintiff is able to convince the attorney to run on a contingency basis. At that point, the plaintiff would only be paying for costs like filing fees and things like that, but would not be paying the attorney. The attorney's banking on getting his money out on the back end. Whereas the defendant is forking over, let's say $350 an hour, maybe more, maybe less. but the defendant is going to be forking over a lot more money. So it is, when you consider that every 2 to 3 hours the defendant's forking over $1,000, and hours can run up pretty quick. I mean, you spend a full week of working on motions and going through evidence and things like that. I mean, maybe you have 40, 50 hours. That's $20,000 to $25,000 maybe. So if you're wondering about some of these settlements, it's because there's always, this is one of the first things I learned, is that there's always settlement value. There's always settlement value in a complaint. It may not be much, but there's always settlement value. So that's something to think about. Was there something else I wanted to talk about? Probably there was, but I can't think of it right now. So anyway, thanks for watching. Have a great day.